Hello, welcome to the Family Law section of the ULV Justice Center website. Glad to have you. In this video, I will be covering some pre-suit considerations for divorce, legal separation, and annulment in California. Before I get started, I want to remind everyone that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise that you consult with an attorney. What I mean by pre-suit considerations are just things you should consider before opening a case. This includes whether you are planning to file for a divorce, legal separation, or annulment, what are the grounds for a divorce, legal separation, and annulment, what court will have jurisdiction over the case, who will be the petitioner and who will be the respondent, whether you can afford the filing fees or if you will need to seek a fee waiver, and how you will have the other party served with court documents. A divorce and legal separation are very similar in that both actions divide the parties' properties and debts, decide custody of minor children, and determine spousal and child support. The biggest difference between the two is that at the end of a divorce, the parties are no longer married, meaning they are considered single and can remarry. In a legal separation, the parties are still married, they are not considered single, and they cannot remarry. People may decide to legally separate instead of divorce for religious or personal reasons. Annulment is unique because at the end of an annulment, the court is basically saying that the marriage never existed. Void marriages, which are marriages that will never be recognized, include bigamy, meaning a partner is married to more than one person, or incest, so when close relatives marry, such as cousins. Voidable marriages are marriages that will remain valid until one partner contests the marriage in court. This includes a partner that was a minor at the time of entering the marriage, a partner who was of unsound mind at the time of entering the marriage, a partner who was frauded or forced into entering the marriage, a partner who has an incurable physical incapacity that interferes with their ability to have sex, or a previous marriage. Previous marriage is one of those rare occasions where, say, a spouse goes missing for years and it is assumed they are dead. The living partner goes on to marry someone else, then suddenly the supposedly dead spouse reappears, thus invalidating the second marriage. Unlike a divorce or legal separation, there are statutes of limitations for annulment, meaning filing must be done within a certain time frame. The statute of limitation depends on what ground you are basing your annulment on. For example, the statute of limitations for a partner who was underage at the time of marrying is 4 years after the underage partner turns 18. If 5 years have passed and the partner then decides they want to file for annulment, they cannot because the statute of limitations has passed and they would have to file for a divorce instead. Grounds is a reason specified by law that serves as a basis for you demanding relief, or in other words, why the court should give you what you're asking for. California is a no-fault state, meaning you do not have to prove how bad your spouse was to you in order to get a divorce or legal separation. You just simply have to claim irreconcilable differences or incurable insanity. Irreconcilable differences means differences which has caused the complete breakdown of the marriage, which cannot be repaired by counseling or other efforts. You are basically saying that no amount of therapy or counseling will fix the marriage. Incurable insanity is rarely used and is more burdensome because you have to prove the other spouse is insane. So it is better to just claim irreconcilable differences. The grounds for an annulment are all the different reasons I previously mentioned, such as an underage partner. Jurisdiction means the power the court has to hear a case and make orders. Family law is a state matter, meaning you will never file for a divorce, legal separation, or annulment in a federal court. Family law matters in California are always filed in superior courts, which is just a name for trial courts in California. To file for a divorce in California, at least one party must meet both of these residency requirements. They must have resided in the state of California for at least 6 months prior to the filing of the petition, and they must have resided in the county in which the action is being filed for at least 3 months prior to the filing of the petition. So if I have lived in California for the last 6 months, and I have lived in Laverne for the last 3 months, then I can file in Los Angeles County. The court has power over all property in California and can divide all property of the marriage before it, but they do not have the same power with property that is outside of California. The court only has jurisdiction over certain children. The court cannot make orders regarding children who have lived in California for less than 6 months, who are abducted from another state, who are American Indians, or who are in the custody of the juvenile court. If the parties have children together, they will need to fill out and file a form entitled Declaration under Uniform Child Custody, Jurisdiction, and Enforcement Act, also known as the UCCJEA. This document ensures the court that they have jurisdiction over the parties' children and can make enforceable orders regarding child custody, visitation, and support. The court must also have jurisdiction over the respondent to make enforceable orders against them. To do this, the respondent must be personally served with notice of the lawsuit, which I will talk about later on. If you live in Los Angeles County and you want to make sure you are filing at the right courthouse, copy this link into your search bar. Once you are on this page, you will type in the city or zip code for where you live. For this example, I live in Laverne and my zip code is 91750. Once I do a search, I'll see this. I can see that if I want to start a family law case, I would have to go to the Pomona Courthouse South. The petitioner is the person that opens the case by filing a petition. Documents that the petitioner must file with the court include a petition, a summons, a UCCJEA if there are minor children from the relationship, and a family law case cover sheet if filing in Los Angeles County. Keep in mind that every county may have different case cover sheet requirements. If you are filing in a different county, you will need to check what the filing requirements are for that county. The respondent is the person responding to the petition. Documents that the respondent must file with the court and serve onto the petitioner include a response and a UCCJEA if there are minor children from the relationship. Once the respondent is served with the petition, they will only have 30 days to file their response with the court. If the respondent misses its deadline and never filed a response with the court, the petitioner can request to enter default. This means the court will move ahead with the case and make orders, such as with property division or support, without the respondent's input. If you are the respondent, you want to make sure you do not miss this deadline. The filing fee for the petition and response is $435. If you cannot afford this, you may ask the court for a fee waiver. There are 3 different ways you can qualify for a fee waiver. These include if you are receiving public benefits, if your household income before taxes is less than the amounts listed on the fee waiver form in Section 5B, or if the court finds you don't have enough income to pay for your household's basic needs and the court fees. If you want to ask the court for a fee waiver, you must fill out the form titled Request to Waive Court Fees, sign the form, make 2 copies of the completed form, and turn in your fee waiver forms to the court. I would also recommend reading the information sheet on waiver of superior court fees and costs because it gives more in-depth information on how to request a fee waiver. I have previously mentioned personal service, and this is particularly important for the petitioner. When starting a family law case, you must have the respondent personally served with notice of the lawsuit. Otherwise, the court does not have power over the respondent and cannot make enforceable orders against them. You will need to have the respondent served with copies of all the documents you filed with the court, including copies of the petition, the summons, the UCCJEA, the case cover sheet, and a blank response and blanks of any other documents that you filed with the court. For example, if you filed a UCCJEA, you would need to provide a blank UCCJEA to the respondent. The petitioner cannot serve the respondent themselves because they are a party to the lawsuit, so they will need to find someone else to serve the respondent. The server must be someone who is 18 or older and who is not a party to the lawsuit. After the server has served the respondent, they will need to fill out and file a proof of service of summons with the court. Before you open a case, you should arrange to have a friend or relative serve the other party for you. This has been an overview of some pre-suit considerations for divorce, legal separation, and annulment in California. On behalf of the ULV Justice Center, we thank you for your time and hope this information is helpful in your legal matter.